You're driving home. Red and blue lights flash behind you. The officer approaches and asks one question. What you say in the next few seconds can completely change the outcome of this encounter. Every day, thousands of drivers make critical mistakes during traffic stops. They believe that being talkative and cooperative will help their situation. But the law doesn't reward people for talking. It rewards those who understand their constitutional rights and know exactly when to exercise them. After reviewing hundreds of traffic stop cases and Supreme Court decisions, I've identified 4 specific responses that can protect your legal rights during any traffic stop. Failing to use even one of these phrases can give officers legal permission to search your vehicle and extend your detention. Using all 4 properly means you walk away with your constitutional protections intact. Let's examine the 4 common mistakes people make and the 4 exact phrases that safeguard your rights. Mistake 1. Answering. Do you know why I pulled you over? The mistake. The officer walks up to your window. His body camera is recording. He asks, do you know why I pulled you over? Most people immediately start guessing. They try to explain. They end up admitting to something. I think I was going a little fast. Was I speeding? I didn't see that stop sign. Congratulations. You just provided a recorded confession before the officer even told you what he observed. The scenario. You're driving on a road where the speed limit is 35 mph. Red and blue lights appear behind you. The officer approaches with his body camera recording. He asks, do you know why I stopped you? You want to appear cooperative, so you respond, was I speeding? The officer nods. You were doing 48 in a 35. Maybe you weren't actually speeding, but that doesn't matter anymore. You already admitted on camera that you knew you were going too fast. Why people do it? Most people think being honest and forthcoming makes them look better. They believe the officer will appreciate their cooperation. But officers aren't your friends during a traffic stop. They're investigators collecting evidence for potential citations or arrests. Legal reality. In Salinas versus Texas, 2013, the Supreme Court ruled that you must explicitly invoke your Fifth Amendment protection. If you voluntarily answer questions, you've waived your right to remain silent for that interaction. Your admission becomes admissible evidence against you. The body camera captures you admitting to speeding. Later, a prosecutor can play that exact clip in court. Your case becomes much harder to defend. Evidence problem. Body cameras record every word. When you say, I think I was speeding, that statement becomes a confession. Your own words damage your defense. The officer doesn't even need radar evidence. Your admission alone can be enough. Officer psychology. Law enforcement officers receive training on these questioning techniques. It's a tactical approach. Most people will admit to something when asked this question. From the officer's perspective, it's a win regardless of your answer. The correct response. Here's phrase 1, and it's simple. No, officer. That's it. Stay calm, remain polite, and be clear. No, officer. You're not being rude. You're protecting your legal rights. If the officer follows up with additional questions about whether you know the reason for the stop, repeat your answer. No, officer. Why this works? This response forces the officer to state his reason for the stop on the official record. You haven't admitted to anything. You've protected yourself legally while remaining completely respectful. The body camera footage will show you were polite and cooperative, but you didn't hand the officer evidence to use against you. Bottom line, never answer. Do you know why I pulled you over? With anything other than, no, officer. Every other response is essentially a confession waiting to be used against you. This invokes your protection under the Fifth Amendment's self-incrimination clause from Salinas versus Texas. However, the Fifth Amendment only protects your right to remain silent. It doesn't protect you from physical searches of your person or vehicle. That's where the Fourth Amendment becomes essential, because mistake 2 involves giving officers permission to completely bypass Fourth Amendment protections with a single word. Mistake 2. Consenting to searches. The mistake. The officer finishes writing your citation. You think the encounter is over. Then he asks, you don't mind if I take a quick look in your car, do you? Most people freeze. They don't want to appear guilty, so they respond, sure, go ahead. That one word just waived your Fourth Amendment rights completely. The scenario. You're pulled over for a broken taillight. The officer returns with a warning. No citation. You're relieved. Then he asks, "You don't mind if I look around, do you?" You hesitate. If you refuse, won't that seem suspicious? So you say yes. The officer proceeds to search everything. Your glove compartment, center console, under the seats, the trunk. 20 minutes later, your vehicle has been thoroughly searched. He finds nothing because there was nothing to find. He leaves. You're left wondering, why did I agree to that? Why people do it? People think refusing a search makes them look guilty. They believe saying no will make the situation worse. They assume the officer will just get a warrant anyway. So why bother refusing? But here's what you need to understand. If the officer had legal grounds to search your vehicle, he wouldn't be asking for your permission. He would simply conduct the search based on probable cause. When an officer asks for consent, it's because he lacks probable cause. He's fishing for evidence. You have no obligation to assist with that fishing expedition. Legal reality. The Fourth Amendment protects you against unreasonable searches and seizures. However, you can waive that protection. The moment you say yes to a search request, you've done exactly that. Courts have consistently held that voluntary consent eliminates the requirement for a warrant. If you give permission, the search is legally valid, and anything discovered during that search can be used as evidence against you. Consent means the officer can search everywhere in your vehicle, and if he discovers anything illegal or suspicious, you're held responsible. Evidence problem. Once you consent, everything discovered becomes admissible evidence. You cannot challenge the legality of that search later in court. The body camera footage shows you agreeing to the search. That's your Fourth Amendment protection waived on video. Officer psychology. Officers know that most people will consent to searches. They receive training on how to phrase the request in ways that make refusing feel wrong. You don't mind, do you? You don't have anything to hide, right? This will just take a minute. These are deliberate tactics, but refusing consent is your constitutional right, not a sign of guilt. The correct response. Here's phrase 2. I do not consent to searches. Say it clearly, calmly, and firmly. I do not consent to searches. If the officer pushes back or asks again, repeat the same phrase. Don't argue about it. Don't try to explain your reasoning. Simply state your refusal. Why this works? This response puts the burden back on the officer. If he wants to search your vehicle now, he needs to establish probable cause. He needs legal justification that he can articulate. He cannot rely on your permission because you explicitly refuse to give it. And if he searches anyway, without probable cause, you've created an official record. The body camera shows you clearly refused consent. That gives your attorney solid grounds to challenge the legality of that search later, if it violated your rights. You're not being difficult. You're exercising constitutional protection. That protection exists specifically for situations like this. Bottom line, never consent to a search, regardless of how innocent you are or how much you have nothing to hide. The correct answer is always, I do not consent to searches. This protects your Fourth Amendment right against unreasonable searches. However, refusing consent doesn't automatically end the traffic stop. Officers can still detain you if they have reasonable suspicion under Terry v. Ohio. This brings us to a critical distinction that most people don't understand: the difference between a voluntary encounter and a lawful detention. Mistake 3 is failing to clarify which type of encounter you're actually in. Mistake 3, not asking, "Am I free to leave?" The mistake: the officer hands you your citation. You sign it. He walks back to his patrol car, but he doesn't drive away. He just sits there, watching you. You're not sure what to do. Are you free to go? Should you wait? Should you ask? Most people just sit there waiting, feeling uncomfortable, not wanting to seem rude or confrontational. But every second you wait without clarifying your status is a second you're voluntarily extending the encounter. The scenario: the officer gives you a speeding ticket. The traffic stop should be over, but instead of leaving, he stands by your window asking additional questions. Where are you headed? Where are you coming from? Have you had anything to drink tonight? You answer these questions because you think you have to. He's still there, so you assume you must respond. But here's the question most people never think to ask: Am I being detained, or am I free to leave? Without asking that question, you're stuck in legal limbo. You don't know if this is a voluntary conversation or a lawful detention, and that uncertainty works entirely in the officer's favor. Why people do it? People assume the traffic stop continues until the officer explicitly says it's over. They think they must answer every question the officer asks. They believe that ending the encounter themselves would be rude or even illegal. But there are three types of police encounters under the law. First, voluntary encounters, where you're free to leave. Second, Terry stops detentions, which are brief detentions based on reasonable suspicion. Third, arrests, where you're in custody. Most people don't know which type they're in, and officers often exploit that confusion. Legal reality, Terry v. Ohio, 1968, established that officers can briefly detain someone if they have specific, articulable facts suggesting criminal activity. But the key word is briefly. Rodriguez v. United States, 2015, ruled that officers cannot prolong a traffic stop beyond the time reasonably necessary to complete the purpose of the stop, unless they develop reasonable suspicion of another crime. So once the officer writes your citation, the legal justification for the initial stop ends. If he keeps you there without reasonable suspicion of additional criminal activity, that's unlawful detention. Evidence problem. Body cameras record everything. If you sit there answering questions for 30 minutes without asking if you're free to leave, the footage makes it appear completely voluntary. That undermines any later claim of unlawful detention. A prosecutor will argue you never tried to leave. You never objected. You appeared willing to continue the conversation. But if the body camera shows you asking, "Am I free to leave?" and the officer responding, "No," now you have proof. Proof that you wanted to end the encounter. Proof that the officer prolonged it beyond what was necessary. Officer psychology. Officers know that most people won't ask if they're free to leave. They count on that silence. When people do ask, some officers give vague, non-responsive answers. Just a few more questions. We're almost done here. This won't take long. These are stall tactics, and they work because most people don't push back by asking the question again directly. The correct response. Here's phrase 3, and this one clarifies your legal status immediately. Am I free to leave? Ask it calmly, respectfully, but clearly. Am I free to leave? If the officer says yes, thank him, roll up your window, and drive away. The stop is over. Don't linger. Don't continue the conversation. Leave. If the officer says no, you now know with certainty that you're being detained. At that point, you should invoke phrase 2. I do not consent to searches, and phrase 4, which we'll cover next. I invoke my Fifth Amendment right to remain silent. Why this works? This question puts the legal burden on the officer. If you're free to leave, and he says yes, the encounter ends immediately. If he says no, he must be able to articulate reasonable suspicion for continuing the detention. If he cannot articulate that reasonable suspicion, your attorney can challenge the detention as unlawful. But you can only do that if you ask the question and received a clear answer. Bottom line, always ask, am I free to leave? Don't assume anything. Don't wait around hoping the officer will tell you. Don't guess about your status. Ask directly and clearly. If the answer is yes, leave immediately. If the answer is no, stay silent and invoke your rights. This question clarifies your legal status under Terry v. Ohio and protects you from unlawful detention under Rodriguez v. United States. But there's one more constitutional protection you must invoke explicitly, and it's the most misunderstood right of all. Because Salinas v. Texas established that simply staying silent isn't enough. You must affirmatively claim the privilege. Mistake 4 is thinking that silence alone protects you. Mistake 4. Staying silent without invoking the Fifth Amendment. The mistake. The officer asks you a question. Have you been drinking? Where are you coming from? Do you know there's an odor of marijuana in this vehicle? You don't want to answer, so you stay quiet. You think silence is your right. You believe that remaining silent automatically invokes your Fifth Amendment protection. But the Supreme Court ruled otherwise, and your silence can actually be used against you in court. The scenario. The officer asks, have you had anything to drink tonight? You don't answer. You just stay quiet. He asks again, "Sir, have you been drinking?" Still no answer from you. Why won't you answer? What are you hiding? You remain silent, thinking you're legally protected. But weeks later in court, the prosecutor plays the body camera footage. Ladies and gentlemen, when asked if he'd been drinking, the defendant refused to answer. His silence demonstrates consciousness of guilt. An innocent person would have simply said no. The jury watches you on screen, silent and looking uncomfortable. And they think to themselves, if he had nothing to hide, why didn't he just answer the question? That's the problem. Silence without explicit invocation can look like guilt. Why people do it? People think silence is automatic protection. They believe the Fifth Amendment means they don't have to say anything. They assume that staying quiet is the same as invoking the right. But Salinas versus Texas changed that understanding. The court ruled that you must explicitly invoke your Fifth Amendment protection. Silence alone isn't sufficient. You have to actually say the words. Legal reality. In the Salinas case, the defendant voluntarily went to a police station for questioning. He answered questions for about an hour. Then an officer asked whether his shotgun would match shell casings found at a murder scene. The defendant went silent. He didn't answer that question. At trial, the prosecutor used that silence as evidence of guilt. The Supreme Court said this was legally permissible. Justice Alito wrote in his opinion, "A witness who desires the protection of the privilege must claim it. If you want the Fifth Amendment to protect you, you have to invoke it out loud." Evidence problem. Body camera footage captures your silence, and without explicit invocation of your Fifth Amendment rights, that silence becomes evidence that can be used against you. The prosecutor can argue. He had every opportunity to deny the allegation. He chose not to. That tells you something about his guilt. Juries often accept this argument because to a reasonable person, if you're innocent, you just say so. Silence appears suspicious unless you explain why you're being silent. And the legal explanation is invoking your Fifth Amendment right. Officer psychology. Officers know about the Salinas decision. They understand that your silence can be used against you if you don't explicitly invoke your rights. So they keep asking questions. They push. They probe. They wait for you to either answer and potentially incriminate yourself, or stay silent and appear guilty. Either way, they win, unless you properly invoke your constitutional protection. The correct response. Here's phrase 4, and this completes your legal protection. I invoke my Fifth Amendment right to remain silent. Or more simply, I plead the Fifth. Either version works, but you must say it out loud. I invoke my Fifth Amendment right to remain silent. If the officer continues asking questions, repeat the same phrase. I invoke my Fifth Amendment right to remain silent. Don't explain your reasoning. Don't elaborate. Don't add anything else. Simply invoke the right and stop talking. Why this works. This explicitly invokes your Fifth Amendment protection. Now your silence is legally protected under the Constitution. The prosecutor cannot use it as evidence of guilt. The officer cannot claim you are being evasive or suspicious. You've clearly stated that you're exercising a constitutional right, and exercising a constitutional right cannot be used as evidence of guilt. That's a well-established law. The body camera shows you properly invoking the Fifth Amendment. That's your legal shield. That's proof you weren't being difficult or hiding something. You were asserting your constitutional rights. Bottom line, never remain silent without invoking your Fifth Amendment protection. Always say the words out loud. I invoke my Fifth Amendment right to remain silent. Or I plead the Fifth. That explicit invocation is the only thing that protects your silence from being used against you in court. Here's what you need to understand about traffic stops. They're not casual conversations. They're legal interactions where every word you say can and will be used against you in court. The law doesn't reward people who talk their way through these encounters. It rewards people who understand their rights and know exactly when to exercise them. Let me give you the 4 phrases one more time. Memorize these. Practice them out loud. Because the next time you see red and blue lights in your mirror, these 4 phrases will protect your constitutional rights. Phrase 1. No, officer, when asked if you know why you were stopped. Phrase 2. I do not consent to searches. when asked if the officer can look in your car. Phrase 3. Am I free to leave, when you're uncertain if the stop has ended. Phrase 4. I invoke my Fifth Amendment right to remain silent, when asked questions you don't want to answer. 4 phrases. That's all you need. Stay calm. Stay polite. Use these phrases. Protect yourself legally. Write these phrases down. Keep them in your glove compartment. Practice saying them until they feel completely natural. Because in the moment when your heart is racing and the officer is standing at your window, you won't have time to think through the legal implications. You need these phrases to be automatic. This is educational content only, not legal advice. For specific guidance regarding your situation, consult with a qualified attorney in your jurisdiction. Laws vary by state, and your specific circumstances may require different approaches. You now understand how to protect your constitutional rights during a traffic stop using 4 critical phrases. But there are additional constitutional protections that apply during various types of police encounters. Knowing when and how to invoke those additional rights can make the difference between walking away free or facing charges you didn't anticipate. Understanding the complete legal framework, including when officers can and cannot detain you, what constitutes probable cause versus reasonable suspicion, and how to document potential violations of your rights, provides comprehensive protection. The timing of when you invoke each right matters significantly. Invoke too early, and you might appear confrontational. Invoke too late, and you may have already waived your protections. Understanding those precise moments when each right should be asserted comes from studying additional legal frameworks and Supreme Court decisions that govern police-citizen interactions. The smartest people aren't the ones who try to talk their way out of citations. They're the ones who know exactly what to say, exactly when to say it, and exactly when to stop talking. Stay protected, stay informed, and remember, when in doubt, invoke your Fifth Amendment right to remain silent.